companies incorporated in Ontario were not included. There was some harsh criticism, and it was called a, quote, tepid measure taken by the federal government to address snow washing issues in Canada. Firstly, that 25% ownership is much higher than the 10% threshold set up for public corporations, making it much less useful for potentially identifying illegitimate funds. As well, the registry described by Section 21.1 was to be kept by public corporations, but not actually reported or made public. This significantly limited the use of the registry in identifying those who would snow wash their illegitimate funds. So the 2021 annual budget was released this year on April 19th and was supposed to address some of those issues. The budget proposed to provide $2.1 million over 2 years to Innovation Science and Economic Development Canada to support the implementation of a publicly accessible corporate beneficial ownership registry by 2025. This will significantly change how entities regulated under the Proceeds of Crime, Money Laundering, and Terrorist Financing Act carry out their Know Your Client obligations. A public registry means easily accessible information on beneficial and significant ownership to everybody. While with the implementation of the public registry, Canada's response to snow washing moves it closer to its G7 counterparts, which would theoretically curb money laundering and other illegitimate activity taking place in Canada. So despite the big announcement, we're still currently unsure exactly what the public registry will look like and how useful it'll be. James Cohen of Transparency International Canada suggested the following attributes that the registry should have in order to make the registry as useful as it can possibly be. So the registry should be fully accessible to the public and easy to use and search. The 25% threshold was completely arbitrary, so using the 10% threshold used for public companies would be beneficial. The registry should include data verification systems and carry penalties for providing false information. The federal government should work with the provinces and territories to ensure proper use of the registry, and a tip line should be set up to bolster investigations. And lastly, the registry as proposed is only for private corporations. It should be expanded to include trusts and partnerships, which may be used by money launderers hesitant to test the new registry system. So thank you very much. I'm now going to pass it over to Ken to continue the presentation.
Thank you, Ian. Ian's far too humble to mention the fact that he has an accounting designation as well as being a lawyer, and he understands the numbers that we're talking about here. I wanted to talk about, firstly, the $2.1 million allocation. It sounds like a lot of money, but I mean, having been in Ottawa working on an interchange with the Competition Bureau for a couple of years, I can tell you that $2.1 million actually doesn't go that far. And so it's a good start, but it's certainly nothing like you see in some of the other jurisdictions. The second thing that's important is that there's a tremendous lack of detail. The budget set out the fact that there will be this allocation, but that's basically all that's said. And if you pull the document out, it looks like an election budget. It's full of a lot of platitudes, but there's no detail about this registry. And so we're really in somewhat uncharted waters. And I would say that if anybody has some concerns, and I'll talk about a couple in a minute, feel free to think about making comments to elected officials about this, because it really is something that is still somewhat uncertain. Now, one of the things, though, we can say for sure is that the era of complacency is gone, and that's worldwide as well as Canada. An example, and we put this slide up, is the Financial Action Task Force in June, very recently, came out with a proposal for a risk-based approach to foreign legal persons. I'm not going to take you through this. It's fairly detailed. I just wanted to say that it's out there, that there's a lot of pressure worldwide to bring in a risk-based approach, not only to money laundering, but to beneficial ownership as well. So maybe we could go to the next slide. So let's talk a little bit about risk in the context of beneficial ownership. When you're giving advice to clients, you now, I think, have to say to them, in future, when you're creating these transactions, you have to realize that there may be some public disclosure of the of the organizations that you're setting up. You have to be comfortable with that. They have to know that there are some risks to that, and we'll get to those. So, so you have to be, in today's world, very much alive to a risk assessment. A classic example of this is in the existing money laundering legislation that we have in the Proceeds of Crime, Money Laundering and Terrorist Financing Act. You are actually, if you fall within one of the entities that are required, you have to have a risk assessment program. If you're a bank, for example, a classic example, you must have a risk assessment program. And that risk assessment program shall include the development and application of policies and procedures that will identify the risk of money laundering. Okay, so how do you do that? I mean, everybody says that they're a risk assessment, they understand risk assessment. But I would submit to you, in fact, that a lot of people don't really understand what risk assessment means. And it's a common nomenclature. People, many people have titles. They say they're risk assessment managers, but some of them don't really have any real basic training in the area. Risk assessment requires an understanding of measurement of what is the potential hazard in terms of the potential risk of money laundering. What's the exposure? In medical terms, we call that, what's the dose? How often is this a potential issue for your organization? What is the level of exposure? And ultimately then categorizing that result and coming up with a number. So if we go to the next slide. So if you think about your own practice, how often do you think you're exposed to people that may in fact be money laundering? And, the classic notion of the drug dealer, that's the obvious one, but there's many other areas in which you have to be alive to and think about. And so one of the things that I've talked about in my writing is a risk matrix approach, which is something that's been used in engineering. And if we could go to the next slide. And what a risk matrix does is it gives you priorities for action. So when we talk about the difference between risk assessment and risk management, it's simply this. Risk assessment gives you the number. What is the risk that as an entity, you might be dealing with somebody who's potentially money laundering? Or what is the risk that a client of yours is potentially dealing with or involved in any sort of illegitimate activity? That gives you a number, but now what do you do? Well, what risk management does is it gives you priorities for action. What steps do you need to take, and in what order do you need to take them? So if we could go to the next slide. So this is an example from actually an environmental case, but it shows that what the risk management does is you look on the one axis of the likelihood of money laundering happening, but on the other, you look at severity. What kind of volume are we dealing with? What level of seriousness are we dealing with? And that will give you an assessment of the level of audit, the level of attention that you need to be devoting to this. And why I like this chart analysis is that if you do this in your own organization and you keep a record of this, then God forbid something bad happens and somebody calls into question your potential involvement in what turns out to be a money laundering scheme, you can say, look, I went through this process, I weighed the pros and cons, I applied due diligence, I did not believe that I was involved in anything that was illegitimate. And by the way, here's the chart that I kept and here's my reasoning. And that is actually part of due diligence to be able to actually produce that document. Next slide. So this is another example of the matrix, and we'll go to the next slide. If we could, Ian, could you go to the next slide? So what Ian and I have talked about is, although it's theoretically a good thing and it's a practical thing and it's happening, does the public registry go too far? And one of the concerns of a public registry is it doesn't provide privacy protection. And there are challenges to the release of information. And we could go to the next slide. Lauren Saltman, who introduced this, has written an excellent article called "The New Tax World: No More Secrecy, but instead transparency and automated exchange of information." And one of the things that Lauren points out in that article is that there is a potential danger when you're dealing with a corrupt country whose taxing authority could access what will be a publicly accessible personal information form on the registration form. There is a potential risk here because in corrupt countries, they may use some of that information potentially in a harmful way, where we presume in our country we don't have that issue. Well, now this will be publicly accessible, potentially worldwide. And so we think that that is something that, as we go forward with the public notion, that's something that should be thought about. Now, I should say, out of transparency, I am on the legal committee of Transparency Canada, and work with people like James Cohen. And certainly it's something that I will be saying forward, that although I'm very much in favor of increased transparency and I'm very much in favor of enforcement in the area of white collar crime, I am concerned that there may be some overreach here. We have to be careful, and we have to build in protections, as Lauren has suggested, to protect people, particularly those people who are obviously engaged in legitimate organization and legitimate business. And I think that's where I'll stop. Thank you. Thanks, Ian. I think that's great.
Thanks, Ken and Ian. Terrific presentation. And just for the audience, when this is all finished, our website will have a reproduction of this webinar, so you'll be able to download it and see it again. The next speaker is Lindsay, who's going to talk to us about the modernization of wills and powers of attorney.
Hello, thank you. Everybody hear me okay?
Yes.
Good. So yes, it's not the normal situation where we have any law reform at all in the sleepy area of wills, trusts, powers of attorney, estate administration. So the Estates Bar got very excited over Bill 245. The impetus behind this modernization, which I'm going to speak about, is really in an interesting way, has come from our Attorney General, Douglas Downey. And he's a former real estate lawyer. And he, as a real estate lawyer, was very frustrated with archaic statutes that were still on the books that had not been updated to address changing times. So he's very receptive when members of the bar lobby for some change. And that is why we've been able to see some very interesting changes in our laws. So Kevin, if you can give me the next slide, please. So there's 5 areas I'm going to speak about today. The first one, something that you may already be aware of, was happening during our COVID lockdown crisis, was the ability under emergency legislation to execute wills and powers of attorney through a video conference, something that historically otherwise has been completely invalid under our English common law and under our statutes in Ontario. Secondly, I'm going to talk about a very interesting development where there's a new provision in our legislation allowing a judge to basically validate a will that otherwise wouldn't be valid under the strict rules of testamentary execution requirements, which are traditionally for a formal will, the two witnesses who witness the signature of the testator and then each sign their names as witnesses while the testator watches. There has been legislation in other jurisdictions along these lines, but this is quite a breakthrough for Ontario. Thirdly, I'm going to talk about some new rules regarding the wills of separated spouses. And fourth, some new rules regarding the effect of formal marriage on the validity of a will that was signed prior to the marriage. Finally, there's no new law yet, but there's a new consultation paper on legal authority to make decisions regarding deceased persons, and I'll give a little overview of that. So if I can have the next slide, Kevin. So what we're calling virtual signing or video signing, the government passed regulations under the Emergency Management and Civil Protection Act, and that regulation allowed for signatures under the Succession Law Reform Act to be witnessed during using audio-video communication technology and in counterpart. So during the worst of our COVID lockdowns, when we weren't able to see people in person, and particularly in the winter months when we couldn't even meet and do what we were calling porch signings outside, it became very prevalent for practitioners to be conducting these video signings of wills and powers of attorney. Next slide, please, Kevin. So what has happened is that Bill 245 has actually added this legislation permanently to both the Substitute Decisions Act, which governs execution of powers of attorney for property and personal care, and the Succession Law Reform Act. And both of these changes now authorize permanently virtual signing, which is a huge, huge leap forward in our ability to practice law efficiently and use technology. Next slide, please. So the requirements for using audiovisual communication technology to witness wills are interesting. At least one person who acts as a witness must be a licensee within the meaning of the Law Society Act. So typically that's going to be a lawyer on the other end of the screen, supervising the signing of the will by the testator and by the witnesses. The big change from what we had under the emergency legislation was that the signatures must be contemporaneous. Previously, it was acceptable to have a video conference to watch the testator sign the will, then have a courier pick up the wills, deliver them to the witnesses who'd watched on screen, and then do another video conference where the witnesses would sign. Those practices are, we understand, no longer valid. So what it means now is that everybody must be signing, not necessarily contemporaneously as in terms of everybody signing their signature at the same time, but during the video call, when the testator signs, the witnesses have duplicate documents that are identical, and they also sign as witnesses. So the documents are now completed in counterpart by signing complete and identical copies, but it's all done within the same call. Next slide, please. So although this is convenient, there is no doubt about it, and it's particularly helpful when we have clients who are far away and they don't want to come downtown to our offices to sign their wills, or there's a big rush because they had their wills for 6 months in draft, but then they're catching a plane the next day and want to sign. Clearly, there's a lot of advantages to being able to do these virtual signings, also for people who maybe aren't well or aren't mobile. But there's also a lot of concerns with it. And I can see that it's going to certainly lead to a lot of litigation. I can foresee there will be challenges as to the validity of these documents based on questions of capacity. Because when you're on a video call, you cannot possibly have the same appreciation and nuance of what's going on with the person as you do when you're in the room with them. And, it can be very subtle, but it certainly can be critical. Also, the issue of undue influence. It's very hard to know who's in the room with the individual when you're seeing them on the screen. So, they could be in the corner of the room looking at their screen, but in the other part of the room, there could be someone who's intimidating them in some way. So you can ask them, is there anyone in the room with you? And they will say no, because they've been told to say no. So that is a concern. And again, I can see this leading to issues on both sides of litigation where undue influence is suggested. And then there's the issue of, what if the documents that's signed by the testator on his end of the screen and the witnesses on their end of the screen are not identical? It is possible, we try, not to make errors like that, but it is possible that for whatever reason, in the couriering of documents to the testator and to the witnesses, or printing them off their printers, something happens and there's a glitch and the documents aren't identical. And what forms the valid will under these virtual contemporaneous but counterpart signings is the two documents are basically put together. So instead of like a 25-page will, you have a 50-page will, and you have the signatures on one set of the testator and the other set the witnesses. It's also possible to have the third witness at a different venue. So you could theoretically have a 75-page document with the witnesses having signed contemporaneously, but on different screens. So it makes for a very cumbersome document. There's no doubt about it. It's already led to issues because when we're submitting these wills for probate, we're not sure where to put the exhibit stamp, whether we put it on the back of the page where the testator signed, which is what we normally would do, or on the back of the page where the witnesses have signed. So there's also procedural issues with this situation. And then we also have, I'm very concerned about the acceptance of these virtual counterpart signed documents in other jurisdictions. So if, for example, the testator happens to have a Florida condominium and the document has to be given an ancillary grant down in the state of Florida, which is done quite routinely, and it's not an overwhelming task. I'm not sure that the courts there are going to be completely comfortable when they get a probated document that doesn't have the witnesses' signatures on the same page that the testator signed. So I can see some problems with this in the future. And I think the bottom line, certainly for the time being, is that in-person witnessing continues to be the preferred method of executing wills and powers of attorney. So if at all possible, they should be done in the traditional way. And I think over time, these issues, some of the issues, the procedural issues, the acceptance in other jurisdictions issues will perhaps work their way out in a successful result. But I would rather that my clients not be the ones that are being experimented on if it can be avoided. Having said that, I have done an awful lot of virtual signing over the last year and a half because of COVID. I have the next slide, Kevin. So the next topic, court-ordered validity of wills. Historically, if a document wasn't witnessed properly within the requirements of the Succession Law Reform Act or the old common law, it was a complete fail, and the will was not capable of being probated. So many times in my career, I have had situations where documents been presented. There's clear testamentary intent, and it may be signed by the testator, but it's not witnessed, and it's typewritten. Or there's one witness and two are required. I've had many wills that failed the formal validity test because they were only witnessed by one person. And often you have a situation where someone types it up on their own typewriter in the old days, or their computer now prints it out and asks a neighbor to witness it. Other situations are when a person who's not qualified as a witness witnesses it. So you have someone who's a beneficiary under the will and they witness it. As of January 1st, 2022, there's a new section added to our legislation, which will allow a judge of the Superior Court of Justice to deem a document that is not properly drafted or executed to be valid, so long as the judge is satisfied that the document properly sets out the testamentary intentions of the deceased. We call these substantial compliance laws. And as I indicated at the beginning, there are other provinces and other jurisdictions in the common law where substantial compliance laws have been in place for some time. And there's no doubt that that case law will probably be referred to when these issues come before our judges. It's extremely exciting, I have to say, because it's been incredibly frustrating to have documents that were clear and were clearly testamentary intended, and there was nothing that could be done. They failed, and either a prior will was probated or there was an intestacy. And you can imagine how those sorts of situations lead to very bad family feelings in many cases, and in worst cases, litigation. One thing to know is that electronically signed documents are not capable of being validated under this new section. So if someone does a will on their computer and adds their electronic signature, that will not be valid. Next, are capable of being valid. Next slide, please, Kevin. Just watching my time here for Catherine. I'd like to then move on to new legislation regarding what happens when spouses are separated, but the wills have not been updated. So historically, if a couple who were formally married did wills leaving assets to the surviving spouse, and then they separated but didn't get around to updating their wills, there was no legislation in Ontario that would prohibit the surviving estranged spouse from inheriting under the old will. And it was obviously a source of a lot of heartache. It happened a lot. And people just don't get around to doing these things. In some cases, I had that came across my desk. The couple had been separated for over 10 years, and they weren't getting remarried, so they just sort of saw no need to perhaps go to the expense of being formally divorced, and clearly also didn't update wills. The current legislation before amendment did provide an exception if spouses were divorced. So if a spouse left property to a former spouse from whom they were divorced, then the legislation basically saved the situation and held that the bequest under the will to a divorced spouse was revoked on divorce. And then the will was interpreted as if the former spouse, now a divorced spouse, had predeceased the testator. So that worked out usually very well in terms of what the testator intended when spouses were formally divorced. But if there was no formal divorce, then the estranged spouse still inherited. So as of January 1st, 2022, there's new subsections added to the Succession Law Reform Act, which will treat separated spouses as if they were divorced for the purposes of inheriting under the will. And the result will be much the same as it currently is, where spouses are divorced. And the next slide, please, Kevin. What is considered separated for the purposes, though, of the Succession Law Reform Act? So it sets out the criteria, and there's essentially two criteria, and both must be met. The spouses will have to have lived separate and apart as a result of the breakdown of the marriage for a period of 3 years, and in the period immediately preceding death. And they entered into an agreement that is a valid separation agreement under Part 4 of the Family Law Act. Next slide, please. And I guess there's in some other jurisdictions, it's a year's separation. So that is a kind of an interesting difference here, that we have 3 years. Separated if there's a court order with respect to spouses' rights, or a family arbitration award has been made. Criteria 2, at the time of the testator's death, the spouses were living separate and apart as a result of the breakdown of the marriage. So it's going to be a question of fact as to whether or not these two criteria are satisfied. So criteria 1, there's like several options to establish it, but we will see how much litigation this creates, and I'm sure it will create a lot. The next slide, please. So separation is now to have the effect of divorce on the succession entitlement. And the prior to this bill, a spouse died intestate, that's without a will, and they were legally married but separated. Spouses could still claim the entitlement to the statutory benefits under the Succession Law Reform Act, as well as an equalization payment on death of the first spouse under the Family Law Act. So if a person dies without a will and they're married, there's a preferential share that goes to the surviving spouse. And then if there's one child, the spouse gets half the remaining estate and the child gets the other half. If there's more than one child, the spouse gets 1/3 and the children get 2/3. So that rule continued even if spouses had separated. And that is also going to be reformed under the new legislation. So again, if the spouses are legally married but separated under the requirements of the definition of separation, then they are no longer entitled to inherit on intestacy under the rules of intestate succession in Ontario, and they cannot claim the equalization rights under the Family Law Act. And the Family Law Act provides that if one spouse dies, the survivor is entitled to an equalization of net family property on death. So these are very sweeping reforms. And again, no doubt there's going to be a lot of argument in court over whether there is separation within the meaning of the legislation or not. Have the next slide, please. Marriage and existing wills. Again, this is an important change, but quiet change. It used to be that marriage would revoke a will that was done before marriage, unless the surviving spouse, if the first spouse has died, elected in writing to take their interest under the will that was prepared prior to the marriage and signed. Or if the will said it was made in contemplation of marriage, then that saved the will from being revoked by marriage. So that is now repealed, and it means that if someone has done a will at any time prior to the marriage and then gets married, the will is not revoked, and they really need to update their planning and do a new will. The next slide, please, Kevin. Next slide, Kevin. Thank you. And next slide, please. So this is the final topic I want to speak about before I turn it over. And this is just this discussion paper, consultation paper. There has been issues and concerns about situations where a person has died and there's no one with authority to deal with the remains. And obviously it becomes a very stressful situation. The common law says that the executor under a will has the right to determine the details of burial and funeral, cremation or not, etc. But if a person doesn't have a will, then it becomes a problem. It also becomes a problem where the family and the executor disagree as to what should be done. I have the next slide, please. So there's a proposal that under the current legislation, there's a requires a contract to be made to provide bereavement supplies and services. But if there's no one to sign that contract, then it makes it very difficult for those in authority to deal with the remains. And there's currently no priority of persons establishing who has authority to control the final disposition of the remains of a relative. And as I say, it's led to many difficult situations. And even if there is an executor, it can lead to conflicts and arguments and litigation. Next slide, please. So the changes are proposing that there be a clear hierarchy of the priority of persons with the right to control the final disposition of a person's remains. And, you know, I expect that may be much like the people who have the ability to be attorney or guardian for personal care of a person if they haven't done a power of attorney for personal care. So, you know, typically we go first to spouse, then to children, if no children, then to parents, if no parents and no children, then to siblings and so on. Or if there's adult grandchildren, they may also factor. There's going to be a requirement that suppliers of bereavement contracts obtain proper identification and written authorization from the person with legal authority. And this is probably the most important. There's a proposal that if there are instructions by the deceased regarding the disposition of the remains, that they be considered binding on the person with authority. And this is a problem right now. One can put in their will, for example, what they would like to happen, but the executor does have the final say and has no obligation to follow the wishes of the testator, although they are most often followed. In some cases they aren't, and in sad cases it leads to litigation. So next slide, please. Thank you. And that's it. And with that, I will turn it over to Catherine. Thank you.
You're on mute, Catherine.
Okay, there we go. And we're just gonna, sorry, as I get my technology set up here. There we go. All right. So I'm going to be talking today about the current proposals of changes to US transfer taxes. And you could hear me chuckle a little bit at the beginning because a better topic of this presentation may have been, who knows what's going to happen next. It's a really fun time to be giving advice to clients because, you know, all I can tell them is I kind of have a gut that this is what's going to happen next, but, you know, I don't know any better than the client does about what's coming. So it's been a really challenging time since probably last October to be giving advice. And this is going to cover some of these topics. I think there we go. We'll do it this way. It'll be a little bit better. Okay. So just a current overview of where we are right now in the US, very brief. So the US estate and gift tax, it applies to all US citizens and residents, and it applies to non-residents who are making gifts of US situs property or who die owning US situs property. If you're a US person, you have $11.7 million of exemption per person, and that exemption is unified. So that means if I make a $1 million gift during my lifetime, I file a gift tax return, I let the IRS know I've only got 10.7 left now, and then at my death, I'll have that 10.7. So you can use some of it now, use some of it later. And it's also portable. So what that means is between spouses, you really can double that number and think that the spouses as a unit right now would have 23.4 million. So if husband dies and he only has $1 million of assets, he uses $1 million at his death, the remaining 10.7 he has gets tacked on to what his wife has. That number is indexed annually for inflation. It's not a huge jump. So to give you an example, from 2020 to 2021, it went up to $120,000. So not a big deal. Significantly, the exemption, which is currently at 11.7 and going up a little bit every year, is set to sunset at the end of 2025. It will sunset to $5 million. But then be indexed for inflation. So it'll probably be somewhere in the sixes, really. That is because when they bumped it from 5 to 10, that was the congressional kick the bucket kick the can down the line to the future. And it was only a temporary adjustment. So even if no legislative change happens, we know that it will run out in a few years anyways. So President Biden campaigned on lowering the estate tax exemption, and he was talking about bringing it back to $3.5 million. Now, this goes back to the conversation about gut instinct. I just don't think it will get down to 3.5. That number was what was in effect back in, a decade ago, I think, in the US. And so many people, because your life insurance in the US is included in that number. So your kind of average middle-class person with term life insurance might have an estate tax problem at 3.5. So I think 3.5, it's not going to get that far, but again, who knows? I think more likely if it does go down, it would settle maybe around 5 or 6. But anyways, as it became clear that President Biden was going to win the election and that then those challenges were not going to play out and that the Georgia Senate races were going to go to Democrats and that the Democrats would be in control of the White House and Congress, people started, I don't know if panicking is the right word, maybe planning, but there was some panic that I have to make a gift right now before the end of 2020 because I'm worried that exemption is going to go down and I will have lost the ability to transfer wealth to my family. So at the end of 2020, we were really, really busy making gifts, helping clients make gifts to trusts. One, there was the fear that there was going to be the rollback. There's also this fear that it was going to be retroactive to January 1st, 2021, which constitutionally is supposedly possible. But I always thought it would be hard to fathom that the president was going to be inaugurated third week of January. the first thing he's going to do is attack the estate tax in the middle of a pandemic. There's other things going on. And that, pass legislation in February, March, and we'd make it retroactive to January 1st. But there was this concern that could happen. So 2020 was really the deadline. Well, now we're into July, nothing's happened. And there's still some people who are talking about, well, what happens if he passes it in October and it's retroactive to January 1st? What about all those people who've made gifts in the interim? If I've made a $10 million gift in February, that's retroactive to January, am I going to owe gift tax? I think the fear of retroactivity is past. I can't give anyone guarantees, but I'm much more comfortable with clients now who are looking to make a big gift than I was clients in January. So what were we doing then for clients who wanted to make a big gift? And what the advice we're still giving now is it's really counterintuitive, and it's a hard conversation to have with clients, is that to save your 11.7, you have to give away $11.7 million. Just giving away $1 million, you haven't moved the needle at all. And the reason is, let's say the exemption goes back down to 5, you've made a $1 million gift during your lifetime. The way the calculation works in the US is, because it's kind of that unified system, you look at death and life, is, all right, well, the exemption when I die is 5 million. I made a $1 million gift during my lifetime. How much exemption do I have left at death? I have 4 million. I haven't done anything to save my exemption. I still had 5 total. So really you need to give away 11.7 or give away 10, because you're trying to get that. If it goes to 5, you're trying to give away that excess between, the $10 million gift and it going down to 5 saves you that 5 million you would have lost otherwise. So it's a tough conversation to have. It's why I have an email explanation that's typed up that I've sent to many, many people that shows the math of how that works and why it has to be a large gift. So I've had conversations with clients who have spouses who have $8 million. Right now, they have no federal estate tax problems, but they're worried if it goes to $3.5 million, they're going to owe estate tax, and they want to give something away. And I said, well, you don't have enough to give away to make a difference if the exemption goes down. It will not move the needle. What about spouses with 20 million? In that case, the conversation is usually one spouse should be making the gift at 10 or $11 million to fully use the exemption, save as much as you can for one, and the other spouse doesn't do anything, knowing that they may lose some exemption if the exemption goes down for the couple. You have spouses with $100 million. Well, it's a much easier conversation. It is, okay, if you're comfortable doing so, you can each make a gift of $11.7 million. And because a lot of this gifting has been driven solely by fear of what's going to happen with tax reform. It's not people who are actually wanting to give $11 million to their kids this year, but they're worried about what's going to happen next. So what we're doing for a lot of clients is non-reciprocal slats. So what is a slat? It's a really ridiculous acronym, in my opinion, but it's the Spousal Limited Access Trust. It's just essentially a trust created for the spouse and kids. Wife creates the trust for the benefit of husband and kids, and when husband dies, it goes to the kids. So there's really no magic to calling it a slat, but that's the acronym. And so what we would have is, well, husband wants to create an $11.7 million trust for wife, and wife wants to create an $11.7 million trust for husband. That's possible to do, but it has to be done very carefully, because there is this reciprocal trust doctrine in the US, which is I make a trust for you, you make a trust for me. They're totally identical. Well, we haven't changed our position at all. Those trusts can be unwound as if the gift never happened. So you can still have, his and her trusts, but you have to carefully put tweaks in so they're different from each other. So we've done a lot of non-reciprocal slats in the last year. So now I'm going to talk a little bit about President Biden's tax proposal. It was released, I think, at the very end of April, beginning of May, and it's a really thick book. It's called the Green Book, really thick book of many different proposals, and lo and behold, when you get to the page on the estate tax, there isn't one. As this slide says, the proposed changes to the estate and gift tax rules, none. So all of this worry, all of this gifting and stressing, the word estate tax really doesn't even appear in the proposal. It's something that's been put on the shelf. Could the administration go after it later and try and bring down the exemption amount? Certainly. But right now it's not even on the table, which also that fear of, well, what if something happens in October? Could it be retroactive to January? It's just, I think that's just not even a realistic fear at this point. So I'm going to just very briefly show on the ordinary income tax side, the major changes here is the overall theme on the individual side is it's raising taxes on the highest earners. So here the highest tax rate proposed would go from 37% to 39.6 federally on ordinary income. Now, I stress the word proposed because this is still only in the format of a White House administration proposal. It has not even made it yet into a proposed bill that's being debated in Congress yet. So this is all very fluid still. The bigger change, other than just the rates on ordinary income, the bigger change is going to be capital gains. So right now in the US, long-term capital gains are taxed at either 15 or 20%, depending on where you fall in the brackets. The proposal is for people with adjusted gross income over $1 million that they would start paying capital gains tax like it was ordinary income rates. So basically they'd lose the preference. Also in the proposal, it is that we're using that word retroactive here, that it would be retroactive to the date that this was released. Because obviously, if you've got runway and you know, wait a second, the capital gains rate's about to go up by nearly 20%, I'm going to sell everything off before the end of the year or sell off what I need for liquidity. The proposal is that the increase in the tax rate would go back to August 28th, 2021. So if anyone has sold anything between then and later, they're going to be paying it at that higher rate. So what's going to look very familiar to the Canadian practitioners is also attacking unrealized appreciation as part of this proposal. It's been talked about for a long time that, should we be doing something similar to the Canadian system to try and tax unrealized appreciation? And I personally think that the Canadian system of the deemed disposition at death makes more sense than the estate tax does. But this doesn't make much sense at all because now we're keeping the estate tax and we're going to have the deemed disposition at death essentially. So I'll get to that on the next slide. But here is the proposal it's almost the version of the 21-year rule in Ontario, which is that non-corporate entities, so trusts, partnerships, that own property that has not been subject to a recognition event in the past 90 years would have a deemed sale event and recognize capital gains. So this look back period, it would start to January 1st, 1940, and the first possible recognition would be December 31st, 2030. So another decade out almost. But I mean, there are many, many US families who have trusts that are going back to the 1940s or 1950s. Families like Rockefeller and big names like that people would recognize that own family-owned businesses or own substantial private holdings. And this is saying, we don't care how old you are. We don't care about any grandfathering. You're going to be treated as having sold off the entire trust on the deemed disposition date. Interestingly, there also does not appear to be, at least in the proposal, any, what's going to be the payment plan for this? Is it deemed disposition and you've got to pay all the tax, or is it going to be deemed disposition and you can pay it over X amount of years with interest? That is not addressed with respect to the potential deemed disposition of trusts. In addition, we're looking at transfers made at gift or at death. Currently under US law, property that is given by gift gets carryover basis. So if I bought my IBM stock for $1 and it's worth $100 today, and I give it to my sister, she takes my dollar basis. There's no recognition on the gift. If I die owning that stock and it was worth $100 at death, the basis gets stepped up to $100 and I give it to my sister. My sister could turn around and sell it and she wouldn't have to pay any tax. Well, if this proposal goes through, that will be a thing of the past. Instead, the donor or decedent would be taxed on the appreciation in the asset when it's either gifted or at death. There'd be no more step up in basis, no more carryover basis. This would apply after December 31st, 2021. And there's some fairness to that, whereas that person who sold off their portfolio because they thought the change was coming, they made a conscious effort. You know, somebody who dies mid-year, it'd be really unfair to come back and hit their estate 6 months with later with the retroactive law. So it wouldn't be effective until December 31st. Now there's going to be some exclusions. In the US, we love revocable trusts. And I know in Ontario, you have the alter ego trust for people over certain ages. It's similar concept, but we use them for everyone for probate avoidance. So you can transfer assets from your own name to your revocable trust, and it's completely ignored for income tax purposes. That's going to remain the same. So there'd be no deemed disposition on a transfer to a revocable trust. Similarly, it's going to be completely free transfers between spouses, and the spouse would take carryover basis. Same thing, you could make a donation to charity, they'd get carryover basis and could sell it and not pay tax. So you can give to charity and not have any deemed disposition either. There's an exclusion for tangible personal property. Other than collectibles, that'll be interesting if this law goes forward, how they suss that out. So we're not going to make anyone track the basis on their, IKEA couch, but when do you transfer, when do you switch over from, it's just household furnishings versus now it's an antique collectible? What's that? That's a real fuzzy line. It'll be interesting to see how that gets defined. There will still be a gain exclusion for principal residences, which there is under the current law. So it would translate to an extent. And there'd be a $1 million lifetime exemption for gain on deemed dispositions for gratuitous transfers that you could use during life or at death. And it would also be portable to your surviving spouse if you didn't use your whole $1 million. There's also a proposal that this would not apply to certain family-owned businesses, and that the deferral, you could give your family-owned business to your kids, or at death, you could transfer it to them, and the tax wouldn't be triggered so long as it continues to be a family-owned business. And there's also a proposal that there'd be a 15-year fixed rate payment for transfers at death of non-liquid assets. So you wouldn't have to go sell off the art collection or the vacation house to pay the tax all at once. You could pay it over 15 years. But again, the summary that was put out, the summary proposal, only gives this 15-year payment plan to transfers at death. It does not address gifts or the deemed transfer, deemed disposition and trusts. So I think that if this did move forward, to me, common sense is you'd have to have a payment plan in place, at least for the trusts too. Maybe for gifts, maybe not, because that is a conscious choice, whereas the other two are an automatic trigger. But we'll see what happens. So what is the status of this proposal? It was introduced at the end of April and has not even made it into a written bill yet to be debated. Anyone who's been paying attention to US politics, there's been a lot of back and forth on the giant infrastructure bills that are trying to be passed by Congress right now. And I would have thought that this would have been part and parcel of the infrastructure bill, so that it would be, we're spending all this money, here's how we raise it, it all goes through at once. But it's seeming like this may now be something that's freestanding. So we'll find out more this fall. But until then, it's just a proposal and there's not a lot of details on it. So I laugh when I give you my last slide, which is, do you have any questions? You should have lots, because this is so bare bones sketched out. This is all we know so far. And basically what I've relayed to you is all that's out there. So with that, I will turn it back over, and that concludes the US section of the presentation.
Thank you, Catherine. That was very informative. Even though it's uncertain, we at least know where some of the rocks and shoals are that we want to think about avoiding. We have now come to the end of our presentations. We are open for a few more minutes for questions that anybody wants to raise. You can do so virtually, and we'll try to respond to them. And if there are no questions now, but you think of them later, we'd be happy to respond by email. The invitation that came to you from head of our marketing, Claudio Di Camillo, he'd be pleased to receive any questions and pass them on to the relevant speaker to be able to respond to them. So I don't see any questions at the moment, and so I think I will conclude by thanking all our speakers for excellent presentations, and attendees virtually, thank you for joining us. Hope to see you again for our next Toolbox seminar in the fall. Goodbye and have a great day.